Eve to file one appeal without certified copy, my lord. This is a trademark infringement suit.
When was the order passed?
My lord, the order was initially passed on 25th of July and we applied for certified copy and later it was rectified on 29th July.
Granted.
Grateful, my lord.
Appellates. Appellates. Appellate side commercial division, may I be permitted to mention a matter upon notice is section 37 appeal. This was initially in April 2020, May 2024. The previous bench was pleased to direct the matter to be listed as short hearing matter. It's a 37 appeal, but a lot
37 short.
It was short hearing because it was only on one point. Last order passed, it was.
No, there is no such category.
I know.
Include, list it. List it.
Highly likely.
One thing I should indicate that
Which matter?
This matter probably.
the entire amount has been secured already with the registrar.
That's all right. That is little consolation for them. They don't have it in their hands.
And that security came after a lot of extension and all, but I do not say anything.
What is the above amount?
16 crores is the.
Sure.
My lord, arbitration appeal, my lord, for admission.
Admission.
My lord.
Order 41, Order 41, Rule 11.
No, my lord, it is under section 17 of the Arbitration Act.
দিয়ে দাও এটা অ্যাডমিশন ফেডমিশন না অ্যাপ্লিকেশন বা দিয়ে দিন কি হল কৌশিক আজকেও আসেনি
Your Lordship, may I permit to mention, Your Lordship mentioning for inclusion, Your Lordship.
give the slip.
But I appear on behalf of the respondent.
Well, I'm for the appellant in this case. On the last year, Your Lordship directed to file the supplementary paperwork within a week's time. So we have served the copy on the other side, and in filing, there was a 1-day delay, so department did not accept it. We have the entire records here.
I don't have any problem.
No.
Let him start, my lord.
We have.
No. Give it.
We have one copy only today. One copy is coming now. The entire record of the arbitration proceedings, Your Lordship directed.
So why only one copy, Mr. Sikhania?
No, true.
My clerk,
My lord, this is
the second judge's copy, Your Lordship.
We'll start with one copy, no problem.
Yeah, this is there.
Start.
নিয়ে নাও একটা কপি যেটা দিচ্ছেন
देख अच्छा स्टार्ट करने बोल रहे हैं क्या आया हम लोग
ये तो arbitration proceeding से ही आपको
हाँ।
नहीं मिले आपको क्या मतलब
हाँ पेज नंबर ये है ना ऑर्डर 869 होगा 6 कॉलम में कोटे कोटे और दीते होगा ना हाँ नहीं ठीक है
नहीं हम नहीं डाले इसमें।
फुल क्या ऐसी दिए क्या पिटिशन दिया एडिशनल अपील
Your Lordship, we have not
they-
included
they-
additional grounds of appeal in our paper book because that was
additional they have filed with the paper book has not been yet prepared. Additional appeal you have filed. They have filed.
That is my cross objection. That will be taken later.
paper book is
It is ready, my lord. It could not be filed, but let the appeal be started, my lord. And cross appeal also will consider after completion of this.
That's there paper book has to be filed with
Give it.
Mr. Secretary, you start your appeal.
Yes. Yes.
Are you in any difficulty today?
No. I can
Start.
I can start. So these are the proceedings of arbitration proceedings. Now we don't require actually now. But this is an appeal against the order of single honorable judge.
Allow us to go through the judgment. Take your seat.
Yes, Milord.
Take your seat.
Milord, it is volume 6, Milord.
6 page 870.
From start from 870. Milord.
Hmm.
करना पड़ेगा ठीक है। Okay. ठीक है, अच्छा है। ठीक बोलो।
Yes, Mr. Singhania.
Yes. ठीक kindly see मतलब kindly take मतलब column 4 में just to cut short the matter, the entire claim was there, what the arbitrator has granted and what the single judge grant. Page number 495 column 4 kindly see. हाँ, अब यार बाद में कर लेना ना हाँ थोड़ा सा हेल्प कर दे रहा भाई मोबाइल बाद में कर लेना तो पेज नंबर 495
না কোনটা সাপ্লিমেন্টারি তো একটা, এগুলো সব সাপ্লিমেন্টারি। অরিজিনাল পেপার বুক কোথায়? Yes,
kindly 495 page
yes.
column 4 मतलब this is a description of the total claim by the claimant. Now kindly see मतलब 1 to 12 there are 12 items. Out of these 12 items, the arbitrator has allowed only 6 items. Kindly see that, my lord.
This you are showing us, this is part of the award, 495.
Part of the order. Item 456. Item 456, the arbitrator has not allowed them. Then, my lord, 9, 10, and 12. These 6 items, the arbitrator has not allowed out of 12.
Yes.
And thereafter, you know, in our application under section 34, the London single judge held, he has also set aside the award for 3 items, my lord. The remaining 6 items, 3 items he has set aside. This is, my lord, item number 2, item number 8, and item number 11. 2, 8, and 11. वही तो बचे ना कौन सा सेट किया है 3 सिंगल 8
Yes.
they have no grievance against this.
No, they are filing a cross objection.
We have filed a cross examination in respect of these 3,
So
which has been disallowed by the London single.
only these 3, my lord.
Although allowed by
Therefore-
the London arbitrator, but disallowed by the London single.
They have
judge in
not
section
filed
34 application.
because they have not
This-
filed 34
I have
applications.
filed cross appeal only in respect of that.
So matlab, my lord, out of 12 items 6 goes, my lord, 6 remains there, and in 6 items, my lord, 3 has been set aside by the London honorable single judge. Now 3 remains, my lord. Only 3 remains, 1, 2, and 8, my lord.
No, 1,
1, 2, and 8.
2, 8, and 11 set aside, please.
ठीक है तो correct तो.
Tell you 1,
Claim number 2, 8, and 11 have been disallowed.
137
Yes. 137 allowed.
remains.
137, yes. So my lord, we have to look into the 137 only, my lord. And so far item number 1 is concerned, my lord, this amount they have given, but as per our books, we have to pay them some amount. They claim 2 crores 45 lakhs, and our book shows the entire amount is 1 crore 51 lakhs. That we are agreeable to pay, my lord. Item number 1, my lord. This is the claim for amount withdrawal not released towards CCIT escalation bill, 2 crores 245 lakhs against escalation in parts calculated in terms of its formal provided in the contract. Okay, item number 1. So this we agreed to pay this amount, my lord, 1 crore 51 lakhs. In our books, it is due and we have to pay. So there is no dispute about this also.
Yes, next.
Then, my lord, these 2 items. Now, your lordship has gone through the judgment, my lord. Kindly see the judgment. It.
How much you say?
1 crore 51 lakhs. এটা যদি নিতে চান তাহলে দিয়ে দেবে
Your cross objection is already on record.
We have filed.
कोई आर्बिट्रेटर का पड़े
Yes, yes, yes.
सिंगल बेंच का जज
सिंगल बेंच का
यस
7-6 में है ना 7 में है
Yes,
तो
yes, yes.
7 सिंगल बेंच का
Yes, well, original cross appeal filed, but we had obtained leave from your lordships to add some more grounds in that. That additional grounds ready, but it could not be given.
Yes.
So the additional ground, you know, we will file our counter against the additional also when it comes to
870
now.
870 में है
ठीक है Now, my lord, kindly come to the order, my lord, this 8. Now, although the Honorable Single Judge has admitted that there were some accepted matters which cannot be included in the arbitration proceedings. Number 2, there was some clauses in GCC, general clauses in that. Admission is there that those clauses are applicable. These are, may I read more important points, my lord? Kindly see. Paragraph 3, my lord, of this judgment, single bench judgment. Clearly, 1, 2, 3, 7, 8 are allowed, are accepted matters as per clause 63 of the General Conditions Act. Clause 3, my lord, as per clause 3 of the General Conditions Act. Then 5 also, the clause 62 and 63. And the contractor
Yes,
the claimant will falls in this category. 62 and 63 of
that
the
is your
General
case. That is your case.
Yes, then my case. We have got that agreement. Agreement is admitted by all the parties. And the parties are acting on terms of the agreement. And initially, just a minute, bro. Initially, there were 6 extensions given to the contractor. He has to complete the work earlier within the period given in the agreement. Now, the first agreement.
Mr. Singhani, I will maybe suggest this.
Ah.
To cut down the matter, to keep it brief, you prepare a short notes of argument, written notes of argument,
That will
bring it back. In the meantime, you ensure that your additional application for additional rounds is
Yeah,
filed, serve, and come back next Monday.
Next,
Not Monday.
Monday, I have some personal difficulty.
This Friday.
Yes,
Will you be able to come back by this Friday?
Friday মধ্যে আপনি পারবেন নোটস তৈরি করতে রেডি করতে?
kindly next week, my lord.
Then Friday week.
Friday week.
Friday week.
Friday week. I'll prepare the notes and on that.
এসো লিখো না। উফ, এত কথা বলার কি আছে? এসো।
20
Monday week.
Monday week. But your lordship suggest also to get the notes of argument on our behalf.
Yes.
That would be better.
Better.
Hand over and I will also argue on
Yes, so that you can cut down on your
it. Shorten, yes.
on your oral submission. Whatever you have to say, give us in writing.
Yes.
Because 37 is not the regular appeal.
Correct.
But it's an
We are
appeal.
hearing it every day, Mr. Datta.
Appeal.
This appeal and cross objection are directed against a judgment and order dated August 5, 2024,
That's 5.
passed by a learned judge of this court in AP-Com number 208 of 2024, whereby the learned judge set aside some of the claims allowed by the arbitral tribunal and upheld other claims. stop. Being aggrieved, comma, both the claimant and the respondent have come up. Paragraph. We have heard Mr. Singhania, comma, learned senior counsel representing the Appellant Union of India, comma, at some length. Stop. Paragraph. List the matter once again on কবে হচ্ছে 15th 18th হচ্ছে বোধহয় 18
18th.
August 18
18th August.
18
Ah.
নাকি 18
Yes.
Monday week 18th
Monday
of 2025 under the same heading. Stop. On that date, comma, the parties shall file short notes of argument. And you take steps regarding, we are not saying anything regarding your additional.
Paper book we have filed, kindly record it. But
Paper book or supplementary paper book?
supplementary.
Supplementary paper book filed in court today, be
One
kept with the records.
No, one we are sending.
One set.
No, one
Yes.
we are sending will.
Yes, when will you give us? Today itself.
Today itself. Yes. Today itself.
এই এক লাইন লেখা আছে তাই রেখে দেবে
Below.
I am led by Mr. Jayanta Kumar Mitra, my lord. He is on his way. I am told he is already walking here.
on his way from
From Bar Library, my lord. He is
no,
left
he
to-
was here, we have noticed.
Yes,
We'll
yes.
wait because the first two matters suddenly stopped.
Yes, yes.
I can't remember. শুরু করে দিয়েছিল নাকি এটা? Did he start? No.
He has not started before your lordships. It was in the other, my lord, when your lordships was sitting in the other bench. It started.
এই কৌশিক
Is it your lordship's pleasure to look at the impugned order? Or is it your lordship's pleasure to? Yes.
বাবা অনেক শুনেছিলাম মনে হচ্ছে যাক খুব ভালো না না তুই প্রথম থেকেই করতে হবে যেটুকু দিয়েছিল মানে শুনেছিলাম সেটুকু আমি নোট করে ফেলেছি।
ঠিক আছে। বললাম যে আছে। আমি বলবো। আসছেন না।
Have to start afresh because this is the new bench.
Yes, quite right, my lord. I was sitting over here, my lord. I would have submitted to your lordship that this matter, if taken up after the other matter in which I am arguing, because
I see.
with regard to the damage, my lord, there
Yes.
but my lord, if since your lordship has been pleased to take up, and my lord, the other matters down there, I shall indicate to your lordship, my lord, the way I want to argue this matter. Your lordship has looked into the judgment, impugned judgment.
The other matter is also in the list.
That will be on Friday.
That will be on
That has
Friday.
been kept on Friday.
I see. So if you wish, we can do that. We can finish with that and
The
then
only thing is this, my lord, that after seeing that your lordship has been pleased to take up this matter, many of the learned advocates in the subsequent matters they have, my lord, gone out of the courtroom. So, my lord, I was just wondering whether I can just indicate to your lordship the points I would like to urge.
Yes.
Well, the points I would like to urge is before your lordship is this, because I know after these judgments of the Supreme Court, the jurisdiction of your lordships have become very limited in respect of, my lord, the award passed by an arbitrator. And, my lord, the latest judgment of the Supreme Court that says that even the appeal court jurisdiction is more limited. But of course, I do not know to what extent, my lord, that is acceptable to me. But I shall make my submissions on that. But here, in the being fully conscious of the fact that the court's jurisdiction in the matter of, my lord, an assailment of an award is limited even in respect of interpretation of the contract. Because if the interpretation of the contract by the arbitrator is a reasonable one, then, my lord, the court say that even though we want to differ from that interpretation, we will not touch it. Well, to that extent, the courts have gone. But in the instant case, my lord, my submission will be that the way, my lord, the learned arbitrator has looked into the contractual provision is perhaps not correct. Because I will tell you, lordship, why, how I want to proceed in the matter. My lord, the clause 14 of the annual rate contract is the, my lord, your lordship will please to take up that. I shall indicate to your lordship, page 461. Kindly, my lord, take. This is volume 4. Volume 4. Page 4 starts from page 450. Page 450 is the annual rate contract. The relevant clause is, my lord, clause 14 at page 461. I shall be very restricted in my submissions, being fully conscious of the fact that your lordship jurisdictions are very limited in these facts, in these matters. Kindly come to page 461, clause 14. There are 3 clauses in 3 different contracts which, my lord, govern this particular transaction between the parties. The first one is, my lord, annual rate contract, which I am showing your lordship, clause 14. DVC may terminate short close the contract by not less than 30 days written notice to you, to be given after occurrence of any of the events specified in serial numbers A to D of this clause, and 60 days in the case of the event referred to in serial number 8E and F below. Now, A, B, C, I am not troubling your lordship. Kindly come to D. If you, in the judgment of DVC, has engaged in corrupt or fraudulent practices in completing or in executing the contract, then, my lord, the first thing is this, the 2 terms have been used here, in completing or executing. Now, the learned arbitrator has been pleased to hold this is, my lord, at the inception, when you are entering into the contract, when you if you indulge in corrupt practices. That means you bribe the person who is accepting the contract and things like that. But this is not pertaining to actual execution of the contract. This is well, my submission is this. it is completing or executing. One is, my lord, with regard to, my lord, execution of the contract, and the other is with regard to the performance of the contract. That is. Then, my lord, kindly turn over the page. Page 462. Corrupt practice means the offering, giving, receiving, or soliciting of anything of value to influence the action of the public official in the selection process or in execution. So, my lord, a clear distinction is being made in the contractual provision with regard to the selection, my lord, corruption at the selection process stage, and, my lord, at the contract execution, meaning thereby performance of the contract stage. This had been my submission. Because, my lord, here factually your lordship has been pleased to see, after the contract was executed, the allegation is that in the matter of, my lord, transportation of contract from the railway station to, my lord, the DVC's power plant, my lord, they had been mixing up mud and, my lord, other things with the coal. This is the allegation. So this is with regard to performance of the contract. The learned arbitrator has gone on to say that this is not relevant, because if there is no corruption or fraudulent practice at the time of entering into the contract, then, my lord, the hurdle has been crossed. Then, my lord, next, my lord, kindly see fraudulent practice. II at page 462 means a misrepresentation of facts in order to influence a selection process or the execution of a contract to the detriment of DVC. Now, again, I ask this question: if it is with regard to selection process, was it the intention of the parties to say the same thing in the second part? Selection process or execution of the contract, that means signing of the contract. This is one. Well, then your lordship will please to come to page 480. This is the contract agreement, actual agreement which was executed at page 480. Kindly come to page 484. Cancellation/termination clause 11. Cancellation/termination applicable as per clause 14 under the general terms and conditions annual rate contract. So, my lord, here in the agreement also they refer to and rely upon, my lord, that clause. The third, my lord, the document on which, my lord, the arbitrator has relied upon and will be material for this purpose is, my lord, the general conditions of contract. This is the third document, which is in volume 3. Volume 3, page 408. Page 408. Kindly come to page 415. Here again, my lord, similar clause is there. Clause 17. Cancellation/short closure. The owner may terminate/short close the contract by not less than 30 days written notice to the bidder to be given after occurrence of any of the events specified in serial number A to E of this clause, and 60 days in case of the event referred to in clauses G, H, and F. A, B, C, D, my lord, A, B, C, I am not troubling your lordship. D is if the bidder, again, in the judgment of the owner, has engaged in corrupt or fraudulent practice in competing or executing the contract. For the purpose of this clause, corrupt practice, well, my submission will be that it could not have been the intention of either of the parties that one cannot enter into corrupt practice or fraudulent practice at the time of entering into the contract, but once you have entered into the contract, you can indulge in the corrupt practice or fraudulent practice. This couldn't have been the intention. So that is why, my lord, the two terms have been used, competing or executing. My submission had been competing is at the time of entering into the contract, and executing the contract is performance of the contract. Then, my lord, kindly see that is more clear when definition of corrupt practice in these general conditions of contract. Corrupt practice means the offering, giving, receiving, or soliciting of anything of value to influence the action of the public official in the selection process or contract execution. Well, I just wonder, my lord, what is the why this difference in terminology with regard to selection process or in contract execution? My submission had been the contract execution means performance. And then again, the definition of fraudulent practice also in selection process or execution of a contract. So here, I submit, my lord, this has been made more clear by using the term competing or in executing.
The problem is, Mr. Mithru, again, we are entering the domain of interpretation of a contractual clause.
I know. I know.
And the learned single judge has found this to be a plausible interpretation. His lordship has recorded, we have just gone through the impugned order,
Yes.
that had it been execution of work, that would have meant performance of the contract. But this says execution of the contract.
Correct.
Contract execution. Anyway, that's a question of interpretation, how far we can at
How far,
all.
your lordship?
At all.
Well, I put it this way. I am quite conscious of the fact that in the matter of interpretation of the contract by the arbitral tribunal, the court's hands up, I should say court's jurisdiction is very limited. Let me put it this way. But if your lordship finds that, my lord, the language of the contract is such that it is capable of, my lord, interpretation only in one way, but, my lord, it has not been interpreted in that way, then, my lord, whether the concept of perversity comes in. Because perversity is not necessarily.
That's right. As my brother says, then the view of the arbitrator has to be an impossible view. No reasonable person.
Yes, it's a very tall order.
Wednesbury.
It's a tall order. I know it is a very tall order, but, my lord, we'll have to try. We'll have to. We just can't give it up. Well, there is only one other clause I would request your lordship to look into in volume 3, in this very volume, in special conditions of contract. That is at page 365. So I am just drawing your lordship's attention to the relevant clauses in this contract, so that your lordship has got everything, my lord, at one place. Kindly, my lord, come to page 365. Here, this is the special conditions of contract.
365.
Yes, your lordship, kindly come to page 365. Your lordship has got 365?
Yes.
Kindly come to the bottom. Peculiar way of printing. Special conditions of contract starts from page 366.
Oh, I see.
So, the title is at the bottom. Now, my lord, your lordship kindly comes to page 369. Well, here, I think it is perhaps this the terms here will perhaps give some more credence to my submission. I think so. Clause 15. DVC may terminate or short close the contract by not less than 30 days written notice to the bidder to be given after occurrence of any of the events specified in serial number A to D to this clause, and 60 days in case of the event referred to in clause E and A. Now, D, kindly come to D. If the bidder in the judgment of the owner has engaged in corrupt or fraudulent practices in completing or executing the contract. For the purpose of this clause, corrupt practice means offering, giving, receiving, or soliciting of anything of value to influence the action of the public official in selection process. This is one part, or in contract execution. Now here again, of course, this is couched in such a language, my lord, that it is capable of giving two different interpretation. Then fraudulent practice. Fraudulent practice means misrepresentation of facts in order to influence a selection process or the execution of the contract to the detriment of the owner. But each of these clauses has got clause F. If the owner at its sole discretion decides to terminate the contract, of course, this has been interpreted that this is not an unlimited, unrestricted power of the owner. The owner has to give reasons. Otherwise, it will be arbitrary exercise of power. That, of course, the owner can't do. Even though, my lord, the power is blanket power has been given, but really, my lord, he has to give sufficient reasons for the. Well, this will cause, my lord, subclause F, which contain, my lord, this clause is there in each of these agreements that I have shown to your lordship. If the owner at its discretion decides to terminate the contract, this decision has to be taken on two grounds. Number one, there must be reasons for it. And number two, you must give a hearing. Otherwise, it will be an arbitrary exercise of power. So, my lord, these are the contractual provisions which are there. So, one aspect of the matter is with regard to interpretation of this contract. My endeavor will be to submit to your to persuade your lordship to hold that this interpretation given cannot be a reasonable interpretation for the simple reason that if it is the same thing, it means the selection process and a contract execution means the same thing. First of all, why should the same thing be repeated twice? Number one. Number two, it will lead to absurdity because you are being prevented from influencing the selection process by corrupt practices. But after the execution of the contract, when you are performing the contract, you can do whatever you like. That couldn't have been the interpretation. This is one part of it. I shall make my submissions. Immediate termination of the
All these clauses, Mr. Mitro, termination clauses, the three clauses,
yes, sir.
They all contemplate a notice period. But there's one clause somewhere which
Page
says
438.
that's 438.
Page 438, volume 4.
That's forthwith termination.
Yes. Kindly, my lord, come to page 434, 438. (24.2).
This is what is this part of GCC?
This is the part of, my lord, this is optional terms and conditions at 435. Well, I do not know what all these documents mean, my lord. There are so far, my lord, so many of it starts at volume 2. Just a minute. It starts at volume 2. Oh, sorry, volume 3, page 425. And this continues in volume 4. This is called optional terms and conditions of contract at 425. And this, my lord, one of the clauses is clause 24.2. 24.2, the employer, without prejudice to any other rights or remedies may terminate the contract forthwith in the following circumstances by giving notice of termination and its reasons therefore to the contractor. Referring to this GCC subclause 24.2, your lordship kindly sees here. So, my lord, these clauses are different parts. I mean, different documents, my lord, these clauses are there. 3 of the my lord, 3 of the agreements say that a notice is 30 days and 60 days. Here, my lord, it says it's contract forthwith in the following circumstances.
It's all very confusing. Why do you need so many termination clauses?
I do not know.
The learned judge has held that since here, in this case, the termination was forthwith, it's only clause 24.2 that is relevant.
This is one aspect of the matter. I'm just indicating to your lordship the points are there. My arguments will be very short. This is one point in the matter. Second, which is with regard to quantification of damage. 20% has been given on the total value of the contract.
Loss of profit.
Loss of profit. Remember, this particular aspect of the matter, this particular subject, I find had undergone quite a substantial change over the years. I mean, from Brijpal Singh's case, my lord, 1984 or 85, thereafter a lot of water has run down the Ganges. And I find that the courts have said that it is not as a matter of fact, as a matter of calculation, that you are entitled to get damage. You have to prove that you have suffered damage. Section 73 had been emphasized over and over again. And my lord, the subsequent judgments, particularly, my lord, I found that it is followed the English judgments, where it says that damage is not just a matter for the asking. You just can't come to the court and say, I've suffered damage. You will have to prove how you have suffered damage. I find that most of these judgments say that after the termination of the contract, you will have to show that you didn't have any other opportunity of proceeding with any other contract, or you could not get any other employment in any other place. So if you sit quietly and don't do anything, and then you say that I ask for this, this is a windfall, which the courts will not allow.
Duty to mitigate, yes.
Duty to mitigate. Duty to mitigate, my lord. These are the points which I'm going to argue in the other one. So that's why I submitted to your lordship that perhaps, my lord, my submissions will be. So these are the only 2 points. Ito point. Are it a point? Yes. And the third point is this. My learned friend reminds me, and he's correct. There are notice period mentioned. So in any event, when quantifying the damage, you are entitled to only notice period damage. Nothing more, nothing less. Amritsar gas supply, my lord, that is the judgment which I shall rely upon. And so I am just indicating to my learned friend what are the points that I am going to urge. And these are the only 3 points I am going to urge, and short submission of mine.
Very well. Then we'll keep it after Friday.
After that matter, my lord, if your lordship keeps it, I shall.
It order record karo. This appeal under Section 37 of the Arbitration and Conciliation Act, 1996, is directed against a judgment and order dated August 13, 2024, whereby a learned judge of this court
you can't win.
Dismissed AP-COM number 231 of 2024, being an application under Section 34 of the 1996 Act for setting aside an arbitral award made by a learned sole arbitrator.
A sole arbitrator.
Sole arbitrator in favor of the respondent herein. Stop. Paragraph. Appearing in support of this appeal, Mr. Mithro, learned senior counsel, indicated the following points on which he would develop his argument. Bolun diye choto I. The construction of the termination clause by the arbitrator was perverse. Stop. No reasonable man, no reasonable person would interpret the contract interpret the termination clause in the manner that the arbitrator has done. II, next point of each. Quantum. II, since the termination clauses contemplated a notice period, even if the claimant was entitled to damages, comma, that should have been limited to that notice period. And III, in any event, comma, the onus was on the claimant to prove that it actually suffered loss and damage by reason of termination of the contract. Stop. As a related point, comma, it was also the claimant's duty to mitigate any loss and damage that it was faced with. These are the 3 points in summary.
Absolutely. Your Lordship has admirably summarized my submission.
List the matter 2 weeks hence.
Lordship.
ডেটটা দিয়ে দাও মনে পড়ে যাবে 2 weeks hence. You know, বলো he would develop.
Good. Well, instead of 18th, can it be on the 20th? Or 20th is the middle of the week. I think, my lord,
22nd,
yes, 22nd.
Friday. We'll come back.
Lordship.
Next matter is Mr. Shah's matter. We'll come back. Just.
Item number 4.
Your Lordship, this is my appeal.
I appear for the respondent.
Yes.
Lordship, my lord, this appeal arises out of a Section 34 judgment wherein the award was set aside. What was the award for, my lord? The award was for repayment of the service tax component in one of the railway contracts. Lord, I am the contractor who became the successful bidder and completed the work under the contract. Thereafter, my lord, I have raised the bills along with the service tax which I have asked for from them, but those were not paid. That's how the dispute arose, and thereafter the matter was referred to arbitration, and an award was passed in my favor.
The entire bill was not paid, or only the service tax element?
Only the service tax component. They say that the service tax was already included in the bid amount, but whereas our case was that the service tax component was never considered while considering the bid or while submitting the bid. And now, my lord, first I'll take your lordship to the notice inviting the tender. My lord would find it at volume 5 of my paper book, page 612. And now this tender was floated on 14th of April 2016. And it was supposed to be opened on 27th May 2015.
Six one two.
612, your lordship.
Yes.
So the dates are quite important here. Now, my lord, I'll take your lordship to one notification, which is at volume 3 of my paper book, page.
This tender date is?
My lord, the tender was floated on 14th April 2015, opened on 27th May 2015. Here are 4 notifications that are very pertinent here.
14 May, April. Where do you get that tender date?
Lordship, I'll just indicate, my lord.
15th হচ্ছে কোথায়? হ্যাঁ, correct.
But I'll find the date and give it to your lordship. Now, if your lordship may kindly take the notification for once, I'll give that date, my lord.
You were just now mentioning a tender date. Where did you get it?
My lord, in the statement of claim, it is mentioned. Also in the statement of defense, my lord, it is.
Very well.
Now, my lord may kindly take volume 3, the paper book, volume 3, page 304. The typed version is at 300, next page. Now, by this notification, your lordship, the service tax department has put the amount of incidence that has to be paid by the service provider and by the service recipient. Now, my lord, at page 306, my lord, in respect of this is serial number 8. In respect of services provided or agreed to be provided by way of manpower supply for any purpose. Now, the percentage of incidence, my lord, for the service provider it is 25%, and for the service recipient it is 75%.
What was the scope of your contract?
My lord, it is manpower supply for bedroll distribution in the AC coaches. My lord, those people who
Bread roll distribution.
bedroll, my lord, those who distribute the blankets and pillows and
the
Oh, I see.
food and all those housekeeping stuffs. So, my lord, the incidence of service tax that was back in 2012, as per the notification of the finance department, it was 25% for us and 75% for them. Now, the railway board in 2014, 27th May 2014, releases a notification. Your lordship would find it at page 308 of the same volume. My lord, here they say that 2012 notification is not applicable to the railways, because they are not a body corporate. And for other stuffs, my lord, the notification remains silent. So what they do now is they say that the service tax component is not applicable to the railway contracts, and they don't include it in any of the contracts. So now, my lord, this the NIT was floated in 14th April 2015. But prior to that, on 1st of March 2015, there is another notification. My lord would find it at 311 of the same volume. My lord, here the finance department does what is that 75-25% that ratio, they put the entire incidence on the recipient. So basically, the service provider doesn't need to pay anything. The entire service tax component has to be borne by the service recipient. My lord, that is at page 312. After the first table, again serial number 8 in column 3 and column 4 of the existing entries, the entries nil and 100% shall be respectively be substituted. So basically 2012 notification is amended and or substituted by putting in the entire incidence on the recipient. And this is, my lord, of 1st March, and this was supposed to come to effect on 1st of April 2015. Now on 14th of April 2015, they float this tender.
Again, 14th of April. Achha.
My lord, I'll come to that. My lord, they float this tender. My lord, this tender was floated on the basis of this notification of 2014. The railway never admitted the liability of service tax in the intergenum period. After, my lord, this 1st of March 2015's notification came into effect, my lord, the railway all of a sudden passes another notification that is of 26th May 2015. Your lordship would find it at page 310, volume 3. Lord, may I place it? Government of India has withdrawn the exemption of service tax in work contract with effect from 1/4/2015 via notification number 6 of 2015. Further, it is learned from the budget speech 2015 that service tax is proposed to be increased from 12.36% to 14% from June 2015. Hence, service tax at the rate of 12.36 is now applicable in works contract with effect from 1st April 2015. As per the extent of service tax rules, the above service tax is to be paid by the service provider, that is the contractor. However, a letter is being issued from FA and CAO HQ level to the Railway Board for necessary guidelines for Railway Board regarding contracts executed prior to 1st April 2015. Till such time, a clarification is received, contractor bills are required to be passed by splitting gross amount as basic cost, service tax on 70% of basic cost, payment of service tax being booked to PU 45 in books of railway. You are therefore requested to ensure that all the contractors have obtained service tax registration number, provided service tax registration number along with ST1 and 2 forms to this office. Be advised contractors that service tax is leviable at the rate of 12.36% with effect from 1st April 2015 and 14% with effect from 1/6/2015. This will be on 70% of the basic cost of contract. The same may please be incorporated in works contract agreements of Southeastern Railway. You are also requested to execute supplementary affidavit agreements with the contractors for the contracts finalized prior to 1st of April 2015. This may be also be please be advised to the executives of other departments. This issue will approve these issues with the approval of FA and CAO. So, my lord, they admit that service tax is applicable by way of the 1st March 2015 notification. That is a day before the tender was opened. Now, my lord, the bid value, the tender value, everything was published and or submitted on the basis of 2014's notification of the Railway Board, where they say that 2012's notification is not applicable to them because they are not a body corporate. For the rest issues, the notification remains silent. And now, during the arbitration, my lord, the arbitral tribunal specifically asked for the estimate of the tender. Well, the estimate contains all the factors that has been considered while finalizing the tender amount. My lord, that estimate is at volume 2.
Shouldn't we look at the order of the learned single judge? That is what is under challenge.
Lordship. That is at page 532, volume 4. Volume 4. My lord, page 532.
Take your seat, we'll read it. Take your seat. Yes, sir.
Lordship, I am being led by Mr. Vasu.
Yes, Mr. Basu.
My able junior, my lord, Mr. Raha has placed the notifications before your lordship. My lord, I am not going into it. My lord, your lordship only takes up the order which was passed by the learned single judge.
We just read it.
Yes.
Where's the error? Where's the perversity?
Yes, my lord. Your lordship kindly comes to page 539 onwards.
Internal.
Internal page 7.
Yes.
And your lordship sees paragraph 25. The tender was floated on April 14, 2015.
1 second, Mr. Basu. 1 second. Yes.
Now, the tender was floated on April 14, 2015. Bids were opened on 27 May 2015. LOA was issued to the respondent on June 25, 2015, pursuant to which an agreement was entered into between the parties on September 26, 2015. Then, insofar as the applicability of service tax to work done for the railways is concerned, a notification dated 27th May 2014 made service tax inapplicable to railway works. Such exemption was, however, withdrawn by a subsequent notification dated March 1, 2015, with effect from April 1, 2015, by which the railways were made liable to pay 100% of service tax. However, the said notification was implemented only by a further notification of May 26, 2015. Now I pause here for a moment. Your lordship sees, my lord, the tender was floated on April 14, 2015. The bids were opened on May 27, 2015, and the notification by which it was made applicable for the railways to make reimburse was May 26, 2015. Now in May 26, 2015 notification, my learned junior has placed before your lordship that, my lord, there were two things, two clauses. One, a modification was required to be made for agreements which were prior to a certain date. Secondly, or the clause had to be incorporated by way of a supplementary agreement. That was never done. So if we interpret that, then what is the inference? That whatever was in the interregnum period, whatever clauses were there, whatever the rates were there, and the estimates on the basis of which the rates were given and on the basis of which rate the tender or the quotation was given, that remained the same. The particulars of the estimate which my learned junior has placed will remain the same. There the service tax was never included. Then, my lord, your lordship sees the second error. The learned judge goes on to ignore the estimate, saying that it was an internal document, it could not have been relied upon by the arbitrators. Your lordship now comes to the estimate part. Estimate, my lord, once. And first, my lord, your lordship comes to the 26 May 2015, volume 2, page 310. Good. 310. Fine. No, volume, I'm sorry, my lord, it will be volume 3. My. তোমার পিঠটা কোথায়? দেখাতে হবে না। না, notification করতে হবে।
20th June 2012 notification
Yes.
makes railways 100%.
My lord, 75-25.
20th June,
Yes. 2012.
page 2575, correct.
Yes.
Then comes
2014-27 May, by which the
27th May.
railways say we are not a body corporate, we are not entitled to make payment.
yes.
Then comes 1st March 2015, entire 100% on the service recipient. This one.
Yes.
And the bids were opened on 27th May. The notification comes on 26th May.
No, this 1st March 2015 notification
Yes.
becomes
100%.
operative.
100% on the service recipient.
Becomes operative when?
1st April.
1st April.
Yes.
As mentioned in that notification itself.
Right.
Then 26th May.
Then, my lord, 14th April 2015. That's the NIT. Then, my lord, 26th May 2015 is the notification, by which the railways say, yes, I am entitled to, I am liable to pay, but you have to carry out these two things. ভাই বসুন তো, বলো না আমাকে কোন জায়গায়।
But your bid was inclusive of all taxes.
My lord, my bid would be inclusive of all taxes. That means, my lord, the learned judge went on other taxes. Now, that would be dependent on what was the estimate of the railways, on the basis of which the rate was given in the tender, in the NIT. That did not include the service tax. The reason, my lord, I'll just explain it simply. My lord, what the railways are now saying is, whatever rate was quoted to you, that included the service tax.
Whatever rate was quoted to you.
That was the rate given in the NIT on the
Quoted
basis
by you.
Yes, on the basis, the estimate that was given in the NIT on the basis of which the rates are quoted, that they say was inclusive of the taxes. So I am not liable. You are liable to pay the service taxes because the amount has been paid to you, because it included that, because the amount, the bills that you have raised includes the service tax. They say the bills that you have raised on the basis of those rates includes the service tax.
You should have sought clarification before signing the contract.
But I can, the contract was executed on 14th April, NIT 2015.
Contract was September 2015.
Yes, September, they were supposed to give a supplementary agreement, which they don't give.
You raise no grievance also.
Yes, yes, in the invoices and everywhere, time and again, letters have been given that the service tax.
Where is the NIT? 612.
Well, that's 609 onwards, 612, yes. Yes, estimated basis of this.
तो अब ये थे बताए e-tender देखिए वो बोलছে
যেন কোথায় আসছে এই অ্যামাউন্টটা
Yes, Mr. Basu.
Yes. My lord, your lordship, my lord, comes to, my lord, page 609. My lord, I was on that rate part. Kindly comes to page 609. My lord, I'll just demonstrate that that does not include. It was a report, my lord, given, my lord, dated 27th of March 2015. Now your lordship sees the last paragraph. It is therefore proposed to outsource the work of escorting the AC coaches, assisting the AC coach mechanic and distribution of bedrolls such as an open tender. One estimate amounting to rupees 569,93,604 was prepared based on minimum wages of laborers as circulated by the Chief Labor Commissioner. Now your lordship kindly turns the page, my lord, and comes to page, my lord, just gives me 1 second. Page, my lord, 618. That is a part of the NIT. Rate sheet. Escorting job of coach attendant for bedroll distribution for various trains. Description of work as per schedule. Basic value 569,93,604. Then your lordship sees rates to be quoted in figures. Percentage in figures above, below at, then my lord, clause 1. The tenderer should quote only single percentage above or below at par in figures as well as in words of the above table. If A above or below at par percentage is not quoted and or B rates quoted in words are not tallying, the offer will be rejected. 6. The prices quoted shall be firm and inclusive of all charges, taxes, duties, transportation, etc. Now your lordship comes to the estimate at page 611. Your lordship sees total wages per month, per hour at the bottom. The breakup is there, 55.14. What are the breakups? Per day wages, PF contribution, ESI. Total wages per day, including all benefits, less 1% accepted LOA, such and such. No inclusion of service tax anywhere. Then your lordship kindly comes to that 55.14. Lordly comes to page 639, which is a part of the NIT. Escorting job of coach attendance, unit hours, such and such, rate 55.14. And your lordship sees the amount 569,93,603 or 604, rounded off.
Mr. Gupta, 26th May, you write a letter. It's an internal letter, correspondence.
26th May is a notification.
26th May.
Yes. Financial advisor. White circular number such and such.
Yes, it's railway notification.
Yes.
Very well, railway notification. There, it is mentioned that as per the extent, rules or law, the contractor is to pay service tax. How could that be said in view of the 1st March 2015 Finance Department notification?
May I just indicate here?
Are we clear what we are asking? What are we asking?
The lordship is saying, how could I make a notification applicable subsequent to the date of the notification issued by Finance Department?
On 1st of March 2015, making you 100% liable for service tax. Yes.
I will answer that, my lord. First thing first, your lordship should note that notifications issued by any other ministry or any other department in respect of matters relating to the Finance Department, my lord, Finance Department notifications will overrule them. First. Second is, your lordship.
Car notification kake overrule korbe? Of the railways.
Second, my lord, is that this notification is in respect of those tenders which were already being executed as on 1st of April 2025. Kindly reads the notification once.
Which one?
This page 110. Sorry, 310, volume 3.
That's not a problem.
That we have seen.
Yes.
Third thing, my lord,
Contracts finalized prior to 1st April.
Yes.
We've seen that. We are not on that. This 1st March 2015 Finance Department, Government of India notification making you 100% liable for service tax.
that is not there. May I just Now let us, what has happened
in modification of 20th June 2012.
With cumulative note said that was never modified. And
Never
why I was
modified.
why I say that was never modified is because of the entire thing has been written in the show cause notice issued by the Service Tax Department upon him, pursuant to which he raises this claim. Let us see that notification, that show cause come demand notice. The entire history, how, when the service tax was made applicable on which services, and whether the railways being a body corporate is liable to pay comes under the reverse charge mechanism. Your Lordship remembers during your Lordship's practice days, my Lord, we never charged service tax because the body corporate who has engaged us, we gave our invoices, my Lord, we gave our memo of fees. They will have to pay the service tax to the department, not us. That this is not applicable in case of individuals, my Lord. It is only in case of body corporates, my Lord. That was the reverse charge mechanism, my Lord.
Yes, Mr. Basu, anyway.
My claim was raised, my lord, from 30th of March 2016, not after the show cause notice. Way before. And during the process of the tender, I have given letters.
May I just indicate, my lord? Kindly comes to the show cause notice. Kindly comes to the show. The entirety will be settled, my lord. Kindly comes to page 94, first volume, my lord, the show cause notice. This is 17th November 2017.
Deposition
Comes to Lord, page 104. Paragraph 1.9, bottom of the page. Position prior to 1/7/2012. The service rendered by the SSE were covered either by the definition of commercial or industrial construction services or under works contracts under section such and such of the Finance Act, where the services rendered to railways was kept outside the purview of taxable services. So, my lord, prior to 1/7/2012, no service tax. Now, kindly comes to clause, paragraph 1.12, Lord, at page 05. 105, sir. For position after 1/7/2012, exemptions with effect from 1/7/2012 was extended to various taxable services with the issuance of the mega exemption notification number such and such, dated 26/2012, as per entry number 14 of the said notification. Services by way of construction, erection, commissioning, or installation or original work pertaining to railways has been exempted from the levy of service tax. As per serial number 12 of the said notification, exemption from levy of service tax was excluded to activities like construction, erection, commissioning, installation, completion, fitting out, repairs, maintenance, renovation, or alteration when the same was rendered to a government or a local authority or a government authority. The relevant text of the notification is reproduced below. I am not going into that. undoubtedly the activities of the railways are regulated by the Railway Board as per the policy of Ministry of Railway, which is a part of the central government of India. Thus, it is clear that the SSC provided services to government only. Now, in context of the issue that the SSC undertook maintenance, repairs, alterations, renovations, etc. of various office buildings, hospital staff quarters of South East, it needs to be examined whether the civil structures were such services were used, where for the use of commerce or industry. On a perusal of the text, it appears that the exemption from service tax has been extended only to the such activities of repairing, alteration, renovation of civil structures or original work which are not predominantly used for commercial or industry. Thus, the ultimate use of civil structure of the original work where the services is to be used is of paramount importance for determination of the question of exemption for service tax. It appears that the SSC took various such and such. Now kindly comes to 1.17 below, which is at page 107. Also, since July 2012, Section 65 has been omitted and and all services that came under the definition of service tax as per Section 65B 40, subsection 44 of the Finance Act are taxable services unless such activities fall within the scope of negative list defined under Section 66D. It appears that services provided by SSC like escorting services in AC coaches are liable to service tax. He was exactly doing that, escorting services in the AC coach. So from 1st of July 2012, my lord, the escorting services became taxable. Yes. To pay. The SSC is found to have taken registration only on such and such. Milord, kindly skip over these parts, Milord. Now, Milord, kindly comes. This work order, your lordship will find at 108. Page 100. Sorry. Lordship, please, there is a chart, Milord. Serial number 2 is this particular contract. Now, Milord, will kindly come to page 130. This is the last nail in the coffin, Milord. Last paragraph. There is a partial reverse charge till 31st March 2015, prior to the date, Milord, of floating the tender. In respect of the services of manpower, recruitment or supply agency, where service tax is to be shared jointly by the service provider and the service receiver as per notification number such and such data. But from 1st of April 2015, the liability of 100% service tax payment shifted to service recipient. Though railways also engaged in commercial and business activities, but it is not a body corporate. The provisions of reverse charge mechanism on manpower, recruitment or supply agency shall not be applicable to railways and their And here, whole of the service tax shall be payable by the service provider irrespective of its status.
It is not a body copy. What the service provider has to pay. Yes.
My lord, from 1st of April 2015, irrespective of the fact that I had issued a notice on 26th of May 2015. 1st of April 2015, reverse charge mechanism was not made applicable in respect of service recipients who are not body corporates. Railway is not a body corporate.
So therefore, the service provider will have to pay.
What happens is, my lord, if I am providing,
Will you both come back at 2 o'clock?
May it be kept on some other day.
Yes, we can. Only problem, Mr. Basu, is some other matter will intervene. Your matter will go down in the list. That is the problem. Otherwise, there is no problem.
There's one I've kept, my lord. I've been rebuked, my lord, by one court because of myself. The morning list had collapsed. That is my only difficulty. I would have, my lord.
We'll keep it on Friday then.
after Mr.
Thing is that you'll have to again start afresh, possibly because I would have forgotten everything by then.
I believe
My lord will remember.
No, I don't think it's very point is short.
You know.
Otherwise, interpretation, but point is short.
Mr. Basu, learned senior counsel representing the appellant, begins his argument but does not conclude. Paragraph, we have also heard Mr. Gupta, learned counsel appearing for the respondent. Top paragraph, on the request of Mr. Basu, let this matter be listed again on Friday date.
grateful.
3:30 fixed matter. Who are the learned counsel, Mr. Banerjee? We'll have to refix it because of my doctor's appointment. We'll have to rise at 3:30. The 14th August.
Yes, some difficulty on 14th August. May it be prior to that also.
Prior to, there is no date. If you want a 3:30 time, fix. It can only be after then. After that, 14th por ki ache. 3:30, 18th August.
18th August.
3:30. Ki tarikh ki bar hota? Monday. So reasonably safe. 3:30.
Both the matters, in original side and appellate.
Chalo.
But number 8, 9 and 10, Lordship, I am praying for not to the Lordship. My landed for the other side also present, Lordship. 8, 9, 10, Lordship.
They are related matters.
Yes.
All three. Who is for the other side? Not today.
Not to Lord.
8, 9, 10.
My lord, only one thing, what I find from the order, my lord, is that lordship has not given any date, but lordship had passed an interim order for 10 days. Now, my lord, that would expire, firstly. Secondly, my lord, I will rely on a Supreme Court judgment saying that when the plaint is not restored, interim orders cannot be passed by a court, my lord. So, my lord, that issue, my lord, will kindly consider. They are not there, but I should point out because lordship has not given any date. It's for 10, I should check, 10 days. So, my lord, that will expire. But I will take that point, my lord, because there is a judgment of the Supreme Court saying it cannot be on a similar issue.
Take that point. Nobody is here today.
My lord, I'm for the appeal.
Yes. 18th August
At 3:30.
at 3:30.
My lord, the interim order, if I'm not
That
wrong.
I will be opposing. my lord.
What will happen? What will happen?
Lordship may kindly, because
They are opposing it. They are saying Supreme Court has said unless the plaint is restored, you can't pass an order.
my lord may kindly, because Lordship, the only
They are
difficulty
saying
is
it's
my
illegal.
In a similar matter, my lord, it is
Lordship,
traveled up. Supreme Court has said there is no plaint. So how can there be an interim order passed? Plaint has to be restored first.
number 5 and 6.
There are two appeals. Well, against the same order, and there were two challenges under section 34 against the same award. That is what we are now presently confronted with. Now, so far as this is concerned, this arises out of an agreement. The agreement said that, my lord, I will set up a manufacturing facility. I was the claimant before the arbitrator. I will set up a manufacturing facility which will be dedicated to, my lord, manufacturing, supplying only to my learned friends' clients. That's Kesoram Industries Limited. That is the agreement. And, my lord, for that, they say that they will provide us 50% of the capital for setting up the industry, which will be recovered over a period of time with interest. And the balance infusion of funds will be mine. I am not allowed to sell to any third party. I must sell only to my learned friends' client. That is the sum and substance of the agreement. I shall take your lordships through the agreement.
What was the product?
My lord, 3 products, fly ash bricks. I'll just tell you, lordship. My lord, kindly give me a moment. Yes, my lord. If your lordship will kindly have a look at the agreement itself, it's page 31A.
Thou, volume to thou?
Well, the products are cement ready-mix mortar, AAC blocks, and fly ash bricks. Well, since your lordships are looking to document, I think it will be easier to start with the agreement. Well, 31A. Page 31A, volume 1. The agreement is of 27 January 2016. And your lordships will kindly note that the first party herein is Kesoram Industries Cement Division. And the second party is our client Mintech Global. Your lordship will kindly now have a look at 32A. Well, please see clause 1.3, which talks about the project. Setting up and commissioning of a manufacturing unit to make and produce the end product of cement, ready-mix mortar, AAC blocks, fly ash bricks, and allied products as per the requirement of the first party. Well, this is very important. So it is as per their requirement, their demand, that I have to make these products. If they don't give me a demand, then, my lord, I naturally do not make. But, my lord, they still have to pay me a commitment charge. That is the agreement. Then the manufacturing unit is described. I'll not trouble your lordship with that. Then please see 1.6 talks about the end product. Cement, ready-mix mortar, AAC blocks, fly ash bricks, and alleged products produced, etc. Then, my lord, the minimum assured production is important. That's 1.7. The minimum assured quantity of end products are as follows. Cement ready-mix mortar is 600 metric tons per day. AAC blocks is 500 cubic meters per day, and fly ash bricks and allied products is 400 cubic meters per day. Now, your lordship will kindly, my lord, read this along with, my lord, along with 1.3, which says that the manufacture will be as per the requirement of the first party. That's as per Kesoram's requirement. My lord, I shall gear up my unit to manufacture these producers, my lord, for the quantities mentioned in 1.7. But ultimately, it will have to subscribe to the demand of the first party. Then 1.8, your lordships will have a look. Mobilization advance. 50% of the total project investment cost, along with working capital of the project, as will be mutually agreed upon, which will carry interest at 14.50%. So, my lord, this is the money that they were supposed to advance to us. So 50% is their contribution, 50% is my contribution. And the reason is, my lord, it is really, my lord, the first party which wants us to establish this plant,
for a dedicated source of supply of these products to their units. And we are to ultimately pay it back to them over a period of time with interest at 14.50% per annum. Balance investment is mine. Now, the balance investment, if it is mine, and the dedicated source of supply is only to my learned friend's client, then that investment will have to be protected. And that's how the parties proceed. Now, please have a look at 1.9 now. Consideration in the circumstances where the second party has to ingest huge money for the project. This is recognized. In the circumstances where the second party has to ingest huge money for the project, the first party has agreed to pay up to 50% of the mobilization advance towards land, building, equipment, erection and commissioning cost, pre-commercial production expenses to the second party in terms of clause 1.8 above. First party will purchase the finished goods from the warehouse of the second party at a mutually agreed price as per Annexure 1. However, this will change from time to time on mutual agreement considering escalation of prices. And then, we'll see the responsibility of the second party is the next paragraph, will be responsible for procuring all the necessary raw materials, utilities, services, and human resource for manufacturing the said finished goods. However, the second party has to abide by the quality specifications indicated by the first party. Then, very important, validity of agreement. Please see. The lock-in period of this agreement is mutually agreed at 10 years. However, it may be extended for another 6 years on mutual agreement. So, minimum duration is 10 years. And with a purpose, because my investment will have to come out. I have to make profits for the enterprise that I put in. Then please have a look at clause 1.10b. Binding of agreement. It is agreed that the second party cannot utilize this capacity for manufacturing similar products for any other brand or company during the validity of the agreement. First party agrees to utilize this capacity to 100% before considering any other party for separate manufacturing capacity of same or similar products at any geographical point during validity of the agreement, considering the performance of the second party and keeping in view the new terms of the contract, the second party may be considered for expansion. Well, the second limb is not perhaps important. The first limb says that you can't sell to anyone else. Then, very, very important. This is the clause which really has concerned us all. Exit clause. Whichever party withdraws from its respective contractual obligations under this agreement within lock-in period, such party shall fully indemnify the other party as per the consideration set out in Annexure 3. So, the exit clause really applies to exit within the lock-in period. So, this agreement really becomes indeterminable for the lock-in period. But if you ultimately exit the agreement, then you have to indemnify the other party. And the indemnification provision is set out in Annexure 3. Well, the question that fell for consideration here was the agreement at all terminated? Because it was the requirement was to give a 6-month notice of termination. That, according to the tribunal, unanimously never happened. Now, I will not trouble your lordship with the. Let me just read the preamble also. The first party is a leading cement manufacturer in India. The first party, in order to meet its demand for supply of end product to its customers, has been looking for an entrepreneur that can establish a manufacturing unit in India for the production and delivery of the end product, and in such course came into contact with the second party, and discussions and deliberations thereon, the second party has agreed to establish the manufacturing unit as per the requirement of the first party to produce and deliver the end product to the first party. Consequently, the parties have in concurrence reduced the above into writing. So, it is really at their instance that the industry had to be set up. Then the second party shall establish the manufacturing unit for the production of the end product as per the requirement of the first party. However, first party has to provide 50% of the capex cost as mobilization cost to initiate the project, subject to security to be provided there for either by way of bank guarantee or otherwise to the satisfaction of the first party. First party shall furnish in writing to the second party under acknowledgement all design specifications of the manufacturing unit to be established. Now, my lord, this is important because the unit is established under their directions as per their specifications, their guidelines. It is mutually agreed by the parties that the second party shall complete the establishment of manufacturing unit required by the first party for the purpose of the project within the shortest possible time with joint supervision of first party. That again is very important. From the date of releasing of the mobilization advance for the project by the first party and from the date of delivery of specified engineering designs, layout plan, required specifications of machinery and equipment for the project by the first party under acknowledgement. Well, just pausing here for a moment, I had no independent volition in the matter. It is their designs, their specifications, their supervision that goes into establishing the unit. It is mutually agreed in between the parties that the second party shall purchase the required entire machinery equipment for the project as per the requirement of the first party and install such machinery equipment, etc., under the supervision of the first party and shall thereupon obtain satisfactory certificate from the first party. Well, again, my lord, complete control of the first party. It is mutually agreed in between the parties that the second party shall procure raw material for the manufacturing of the end product after approval of the suitability of the said raw material and its source for making the product. Well, here again, the raw material sourcing is to be supervised and approved. It is mutually agreed in between the parties that the second party shall get the quality and specifications audited by the first party for all the input material. First party will audit the quality and systems by its own personnel. It is mutually agreed between the parties that the second party shall permit deputed personnel of the first party into the manufacturing unit and shall provide access to every part of the manufacturing unit to audit the entire manufacturing process and to note the satisfaction of the first party. It is mutually agreed in between the parties that the first party, after noting its satisfaction of the manufacturing process, after compliance of clauses 5, 6, and 7 above, shall not raise any objection either with regarding the quality or quantity of the end product and shall not withhold payment of consideration. However, the first party can raise such issue at any point of time with evidence thereof, that is objection raised by the user of such product, and second party must take steps to rectify the same to the satisfaction of the first party. The second party shall exclusively obtain all required permissions, licenses for establishment, commission and operation of the unit, etc. Then, mutually agreed between the parties that the mobilization advance given by the first party to the second party will have to be paid back by the second party proportionately in 8 years at the rate of installments as detailed in Annexure 2, and the security furnished by the second party will be reduced in the same manner. My lord, up to here, my lord, we have, my lord, total control of the first party, their audit, their satisfaction with regard to product, and, my lord, the caveat that since you're overseeing the entire process, you will not raise any dispute with regard to the quality. Then, my lord, 11, my lord, says about lifting of the products. The first party is exclusively responsible for logistics of the end product from the warehouse of the second party. Once the first party takes possession of the end product, second party will not be responsible for any deviation in quantity directly to the market. With regards to the quality of finished product, the liability of the second party will be limited to providing the finished product to the first party as per the specification of the first party, and the second party will be responsible for all manufacturing defects. Once the finished products as approved by the first party is handed over to the first party by the second party will have no liability as to its non-manufacturing defect. And then, my lord, your lordship will see at 38A, the second party holds entire liability for any manufacturing process lapse, including any lapse in following prescribed work practices, process parameters, raw material parameters, and finished product parameters. All such process parameters, raw material, and finished goods parameters should be maintained and documented, signed with date, time, batch. Second party is responsible for such, whether checked or missed by the first party. Now, the consideration is important here. That starts from paragraph 12. The first party shall pay the consideration to the second party as per the payment schedule, Annexure 1, irrespective of whether the first party lifts or sells the produced end product from the warehouse. Well, this is very, very important. Now, my lord, that is, my lord, something that connects it to, my lord, the demand of the first party. So, my lord, irrespective of whether you ultimately lift the product or not, my lord, the obligation to pay the consideration for the product, my lord, arises and, my lord, continues. The second party shall pay the consideration to the first party shall pay the consideration to the second party as per the payment schedule, irrespective of whether the first party lifts or sells the produced end product from the warehouse. It is mutually agreed in between the parties that the first party shall seek bank guarantee or collateral as security from the second party, and the second party shall furnish the same for advance only till the plant is commissioned. Then, my lord, liberties, privileges, not really, my lord, important. My lord, this all talks about certification of the processes and the equipment by the first party. And, my lord, similarly, clause 4 is also not perhaps very important. Then, my lord, please see clause 5. Termination of agreement. In the event of termination of this agreement for any reason, the first party shall not have any right or interest over either the manufacturing unit or material stock, etc., which exclusively vests in the second party with absolute right, subject to strict compliance of the terms of this agreement by the second party. And, my lord, then there are these arbitration, severability clauses, etc. Well, the important clauses here, my lord, then are, my lord, those with regard to the schedules. Annexure 1 is at page 43. Please see Annexure 1 at page 43 talks about the pricing mechanism of special ready-mix mortar. Well, I'll not trouble your lordship with the, my lord, various components of pricing here. Now, my lord, please see the note at the bottom of this chart. Remuneration for volume equal to or more than committed capacities. Payment will be made at 52 rupees per pack, inclusive CST and VAT. For volumes less than the committed capacity, payment would be made at 52 rupees for the invoiced quantity, and the commitment charge will be paid on the shortfall quantity at fixed charges net of applicable tax. For calculation of fixed charge, the following component of margin would be added to the fixed charge: 0 to 50% of production, 50% of margin, 51 to 75%, 75% of margin, and for 76 to 100%, 100% of margin. Now, this is the commitment charge. Similarly, if your lordship sees Annexure 1 at page 44, this is the pricing mechanism for fly ash bricks and blocks. Well, variable cost, fixed cost, everything is mentioned. Then again, please have a look at the rate note. Remuneration for volume equal to more than committed capacities. Payment will be made at the rate of 1486 per cubic meter, inclusive of CST and VAT. For volumes less than the committed capacity, payment would be made at 1486 for the invoiced quantity, and a commitment charge will be paid on the shortfall quantity and fixed charges, net of applicable tax. For calculation of fixed charge, the following component of margin would be added to the fixed charge. Again, my lord, similarly mentioned. My lord, what is very, very important is, my lord, if your lordship sees, there are two, my lord, components mentioned. One is for, my lord, for volumes equal to or more than the committed capacities. Then, my lord, the rate is mentioned. If the volume is less than the committed capacity, then, my lord, what happens? The rate is mentioned, plus a commitment charge will be paid on the shortfall quantity at fixed charges, which, my lord, essentially means this, that ultimately, if you do not require me to produce, my lord, produced to the full extent of the capacity of the plant for the product, in that case, to the extent that I produce, you will pay me the invoice value. To the extent I don't produce, you will pay me the commitment charge. And that, my lord, is a fixed component. Agreed. Then your lordship will please have a look at, my lord, similarly at page 45. My lord, this is for the third item. Annexure 1, pricing mechanism for AAC blocks. Again, my lord, the pricing, my lord, criteria is mentioned. My lord, again, please see the note. Remuneration for volume equal to or more than the committed capacities. Payment will be made at 2759 per cubic meter, inclusive of CST and VAT. For volumes less than committed capacity, payment would be made at rupees 2759 for the invoiced quantity, and the commitment charge will be paid on the shortfall quantity at fixed charges net of applicable tax. And then again, my lord, the variations are mentioned 50%, 75%, and so on. Well, this is Annexure 1, which provides for payment of a commitment charge, even if, my lord, the capacity is not, my lord, produced or invoiced. Now, my lord, Annexure 2 talks about, my lord, the recovery of mobilization advance.
This committed capacity, committed
commitment charge.
Committed capacity.
Yes. My lord, here, my lord, if your lordship comes back to the agreement once, my lord, this is what it provides by way of commitment of capacity. My lord, 1.7.
Minimum assured production.
Yes, my lord. 33A. My lord, 600 metric tons, 500 cubic meters, and 400 cubic meters.
So they have committed to lift at least this. Yes.
Now, my lord, Annexure 2, my lord, is mobilization advance and how it is to be recovered. My lord, please have a look at, my lord, page 46. The capital cost for putting up the special ready-mix mortar plant is rupees 11.56 crores. This consists of rupees 50 lakhs for land, 250 lakhs for land development and initially preparatory civil works, 856 lakhs towards plant and machinery and erection commissioning. Period of execution is 4 months. And my lord, then it says that, my lord, total cost of 578 lakhs is to be disbursed. My lord, the manner of disbursement is provided. And it says mobilization advance will not attract any interest till the date of commercial production. The repayment would start from the month which commercial production commences. It would be in 96 equal installments of the principal. Interest will be charged at 14.50% on reducing balance of the principal. So after commencement of commercial production, it is to be adjusted in 96 installments. And then, my lord, if your lordship sees similarly, there's provision for mobilization advance in respect of fly ash recovery blocks, and similarly in respect of, my lord, AAC blocks. My lord, these are really 3, my lord, plants being put up in the same premises. Thereafter, your lordships will kindly have a look at Annexure 3. This provides for exit mechanism and compensation. My lord, this ultimately will have to be read with, my lord, the other provisions, but may I just read this, my lord, once? If any party wishes to terminate the contract during its pendency, it has to give other party 6 months notice in writing to its authorized persons. The notice period will be deemed to start from the date of acknowledgement. So, my lord, this is a condition, my lord, for exit. Then, my lord, what happens if the second party exits? My lord, that is my client. And thereafter, what happens if the first party exits? That is 2A and 2B. Now, well, so far as 2A and 2B is concerned, the second party, in case the first party exists, if the second party agrees to retain the manufacturing facility, second party will have to return the balance mobilization advance along with any pending interest within 1 month from the end of the notice period. So, my lord, that is at the end of the 7th month. If the second party does not wish to keep the manufacturing facility, he shall dispose the facility and settle the mobilization advance as below illustration. So, my lord, the illustration is, my lord, for settling the mobilization advance, how it is to be repaid. And thereafter, your lordship will see at page 50, there's also a calculation of settlement, and then clause 3. In case the opting of the exit clause by either party, the first party may choose to exit 1, 2, or 3 businesses at a time or at different periods of time. Above illustration of settlement of mobilization under advance will be applicable as per investment, depreciation value, realizable value, and time period of each of such facility. Exit subject to full satisfaction of the first party. Now, my lord, your lordship will kindly now once come back to, my lord, some of the principal clauses of the agreement. Your lordship has seen the entirety of the agreement, not a very elaborate agreement at that. But, my lord, the important clauses are here. Your lordship will see, my lord, clause 5 provides for termination. Then, my lord, clause 5, my lord, really provides for termination upon giving 6 months prior notice. Then clause 10, I'm sorry, 1.10a. My lord, first is, my lord, 1.10a, lock-in period of this agreement is mutually agreed at 10 years, may be extended for further 6 years. And thereafter, my lord, 1.11, which is the exit clause, which says that whichever party withdraws from its respective contractual obligation under this agreement within lock-in period, such party shall fully indemnify the other party. Now, my lord, in this case, my lord, what the tribunal did, my lord, there was, my lord, an attempt to terminate, but, my lord, there was no letter of termination that was served. I'll take your lordship through the facts of the case, my lord. There was no letter of termination served, my lord. Our contention was, my lord, this is not a termination at all. If it is not a termination, then you're obliged to, my lord, ultimately continue with the plant for at least 10 years, because that is a lock-in period. And then pay me commitment charges of lock-in for this period of 10 years. My learned friend's contention was that, my lord, I have failed to perform my obligations on the contract. They were justified in terminating. And, my lord, what they purport is, my lord, the letter saying that stop acquiring or procuring raw materials is a notice of termination. Tribunal did not find favor with that argument.
That is their letter.
Yes. Now, my lord, so far as this is concerned, ultimately, my lord, now, my lord, if I may show your lordship, my lord, the claims that were made, my lord, before the tribunal, and, my lord, how the tribunal proceeded to, my lord, adjudicate the claims. I need not show your lordship, my lord, the statement of claim and the statement of defense, because there's a very, very elaborate award. And, my lord, that sets out the necessary, my lord, portions of the statement of claim and the statement of defense as well. My lord, interestingly, my lord, in this case, my lord, some of the claims, my lord, claimed by the claimant were allowed, some were rejected. One of the claims that was allowed was, my lord, for the commitment charges for the balance period of 10 years. My lord, what was not allowed was, my lord, future loss of, my lord, earnings. And, my lord, some other incidental claims. My lord, so far as this is concerned, there was a, my lord, dissenting award, where, my lord, the third arbitrator said that, no, you should also get future, my lord, loss of profit or loss of business. My lord, of course, that is not the majority view. So, my lord, that ultimately did not, is not really the award.
Court-appointed arbitrators or nominated?
No, my lord, nominee arbitrators. Court-appointed. Not court-appointed. My lord, both the claimant and the respondent nominated, and the nominee, my lord, nominees, my lord, decided on the presiding arbitrator. Now, my lord, so far as this is concerned, my lord, without troubling your lordships with the statement of claim and statement of defense, may I show your lordship, my lord, the award itself, which starts at page 1739, that is at volume, my lord, 12. It is a very, very, my lord, voluminous award. It will take, my lord, some doing, but I shall, my lord, try to slowly take your lordships through it. Claimant's nominee কে ছিল? অবধান। Okay, did you care about it?
What is this post of Secretary General of Supreme Court of India?
Secretary,
The third arbitrator?
Oh. No, my lord. Yes, sir. Oh, yes.
ভাই, কোথাও তো নেই কোনো।
এটা কোথায় কোন প্যারাগ্রাফ?
He was your nominee?
Yes, our nominee. Yes, our nominee. This is the first time I have come across this expression also.
Yes.
Minority award is.
Do you know?
Minority award, my lord, is gives them more.
There apparently is, my lord, such a post.
Achha.
Secretary General Supreme Court of India. I never came across this, my lord, expression before. UN, এটা তো UN তো হচ্ছে না, অত দূর যাচ্ছে। My lord, 1744. My lord, paragraph 3 of the award.
But I'm told there is such a post. Because Mr. Moinal post has got notices, my lord, from the secretary there.
Oh, I see.
To be a mediator.
Yes.
My lord, paragraph 3, my lord, notices the agreement, says that disputes, my lord, arose out of the agreement. My lord, then paragraph 4, my lord, are the reliefs that were claimed by the claimant. My lord, there's a claim of 28 crores 73 lakhs 59,526 towards outstanding sum. Then, my lord, there's a claim for interest on the outstanding sum. And then there's future commitment charges. My lord, then 220 Roman 4 is, my lord, something that was not allowed towards future loss of earnings. Roman 5 also, my lord, towards unrecovered depreciation not allowed. Roman 6 is, my lord, for loss of money on distressed sale. My lord, that is also not allowed. And Roman 7 for, my lord, loss of goodwill repute not allowed. The cost of arbitration was, my lord, given. So, my lord, really claims, my lord, 1, 2, 3, and 4. 1, 2, and 3 were awarded, and the rest were, my lord.
1, 2, and 3.
Yes. 1, 2, 3, and, my lord, 8 costs. Then, my lord, the circumstances in which the agreement came to be entered into are, my lord, reproduced. And, my lord, terms of agreement are also reproduced. I do not need to trouble your lordships with that. Your lordships have seen that. My lord, that is, my lord, ultimately, if your lordship sees page 1750, internal page 10 of the award. My lord, Roman 16, the manufacturing plants under the agreement were erected and commissioned under the supervision of the respondent. Periodical meetings were held between the parties and Buildmate in connection with the supply and commissioning of the respective plants. Buildmate was an entity that, my lord, we had introduced. Specified plants under the agreement were successfully commissioned. Dates of commissioning, my lord, are given. I don't think, my lord, there's any dispute in this regard. It says that, my lord, a total cost of 65 crores 74 lakhs 98,124 was incurred for commissioning these plants. Then, my lord, licenses were obtained, etc. My lord, mobilization advance was received, that is recorded. My lord, what is the agreement with regard to recovery of mobilization advance? That is recorded. Now, my lord, please see Roman 20 at page 1751. As per Annexure 1 of the agreement, the respondent is liable to pay fixed charges or commitment charges calculated as per the prescribed mode, and those charges are calculated when the respondent did not utilize the full production capacity source of the respective plant in their designed full capacity. Consequently, the said charges are arrived at computing 100% production capacity, multiplying with total fixed cost and applying the cost of franchise manufacturer's margin at the rate of 16%. And although the manufacturing plants for the respective end products are ready for utilization, the respondent did not utilize the said source of production, and consequently manufacturing plants remained idle, resulting in huge loss to the claimant. Well, this was the claimant's case. The claimant is entitled to recover the project costs and profits from such payments made by the respondent. Though the aforesaid plants for design production of the respective specified end products were ready, even after repeated trial, the respondent did not utilize the full capacity of sorts, which had resulted in a loss to the claimant. The production is also monitored with restricted output of the respondent as per its market strategies, in contrast to the respective plant capacity. Now, so far as this is concerned, the costing of the plant is, then worked out, and the life of the plant is worked out at 20 years. That is Roman 21. Respondent prepared a standard costing sheet based on the initial production as an input for the product pricing for invoicing purposes, and they also provided the rate for charging the commitment charges for the underutilization of the plant, which was confirmed by them by their email of 5th May 2017. The depreciation was charged on straight line method with the assumption of the plant and machinery life as 20 years, and commitment charges included all fixed expenses, including depreciation, interest, salaries, service fees. Standard costing was computed based on manufacturing input or output ratios provided by the respondent. Based on its agreement, the invoices debit notes were raised and settled by the respondent to a certain period only, but not up to the claim period. My lord, what is important here is that, my lord, ultimately the commitment charge was decided by the respondent. As to, my lord, what would be the basis and how it would be worked out for, my lord, less than full utilization of the plant capacities. Then, my lord, the dispute really starts from paragraph Roman 22. The respondent shockingly asked the claimant to put on hold all the raw material deliveries to the plant site until further instructions by their emails dated 7th March 2017 and 8th March 2017. Those correspondence cannot be termed as termination of the contract as per Annexure 3 of the agreement. To invoke termination, the respondent has to serve 6 months advance notice to the claimant, which did not happen in the present case. More so, the respondent during the lock-in period of 10 years, which is clause 1.10a of the agreement, cannot either terminate the agreement or turn the manufacturing plants inoperative, and curiously no cause was aired by the respondent for suspending plant operation. The claimant, however, implemented the said instructions of the respondent and brought the FAB plant, AAC plant, and DMM plant to a standstill, incurring additional expenses to regularly service those plants to keep them fit for production whenever called upon by the respondent. The respondent released some of the claim payment, and after adjustment of those payments, a sum of rupees 4.20 crores remained due to the claimant as on 8th March 2017. And in this regard, the claimant sent an email on 8th March 2017 to the respondent reminding for payment of the outstanding sum. In reply to the said email, the respondent sent an email dated 14th March 2017 admitting that payable sum is 3.79 crores up to February 2017 as against the claim of the claimant, and they counterclaimed that by the commitment charges, the claimant was to pay the periodical repayment of mobilization advance given by the respondent and hurdles due to stoppage of the plants. Then there is exchange of correspondence. After repeated reminders, claimant Respondent released payment of 3 crores on 8th March 2017, 5 crores on 17th May 2017. Well, there were disputes with regard to the calculations that were made. I don't want to trouble you also with that. Then, my lord, if your lordship sees paragraph Roman 26. My lord, this is, my lord, the date of the last payment of 5 crores. In view of the respondent's email dated 17th May 2017, representative of the claimant attended the respondent's office at Hyderabad, clarifying and explaining the genuineness of the claim made by the claimant. After discussions, the respondent proposed reconciliation. And, my lord, the reconciliation, my lord, discussions were going on. My lord, there's, my lord, discussion with regard to, my lord, outstandings. I don't want to trouble your lordship with that now. My lord, paragraph 29, Roman 29. Ultimately, by an email dated 7th August 2017 sent to the claimant, the respondent alleged that it has informed its decision to exit from the project in the month of March 2017, which is not correct. By email dated 10th August 2017 to the respondent, claimant requested for payment of arrears and to permit the claimant to resume operation of the installed plants. My lord, this is, my lord, the purported termination. Then, if your lordship sees, my lord, page 1755, this is the claimant's claim on account of, my lord, outstandings. My lord, it has, my lord, made a computation of these claims for the sum of 28 crores 73 lakhs 59,526. Then 1756, paragraph Roman 31. This is a claim for interest on the outstanding amount. Now, my lord, Roman 36 or 37 is, my lord, important because, my lord, this is the bone of the major controversy. Future commitment charges. Manufacturing unit of the said setup for captive consumption of the respondent on a long-term basis. Life criteria of business is computed on the following factors. Lock-in period agreed in the agreement is 10 years, extendable by additional 6 years. Depreciation computed for the commitment charges calculation considering the life plant as 20 years. Based on the above, the claimant claimed commitment charges for up to 10 years from the respective commissioning dates, and accordingly, commitment charges for all the three end products accrued to rupees 127 crores 12 lakh 64,892. Well, 2016 plant set up, 2017 plant closed. That is the basis on which the commitment charge is claimed, because, my lord, the understanding was you will continue in business for at least 10 years. Well, then there's a claim for future earnings. I don't want to trouble your lordship with that because that has been disallowed and we are not really raising any dispute. Future earnings. My lord, we had made this an issue in our 34 application, but, my lord, that was rejected. We are not, my lord, pressing this claim. And then, my lord, similarly, your lordship finds unrecovered depreciation, unquantifiable claim, distressed sale of assets, reputation, credibility, etc., interim reliefs. My lord, this is the sum and substance of the statement of claim. Well, essentially, you have to pay me, my lord, whatever is due and owing to me. You have to pay me that sum with interest. And you also have to pay me the commitment charges because you have purported not to, my lord, make further demands for products from me. You're saying that you had terminated, but that is not a notice of termination. We don't accept that to be notice of termination. Well, then the defense case is, my lord, set out from paragraph 6 onwards at page 1759. Well, I'll not trouble your lordship with the initial, my lord, few paragraphs, but, my lord, please see paragraph Roman 5 at 1761. Well, after they say that they had paid the mobilization advance, paragraph Roman 5. This is very important. I only rely on this for this purpose. Respondent supplied all engineering designs, layout plans, machinery and equipment list for assisting the claimant in setting up the project. Agreement thus was in the nature of a supply agreement for the end products, and the respondent performed all its obligations under agreement, including prompt release of substantial mobilization advance, etc. Claimant undertook to set up manufacturing units at its own cost. Well, under, of course, the supervision of the respondent, that is the agreement between the parties. And then, my lord, kindly see, there's introduction of, my lord, an erection commissioning contractor, BuildMate, that your lordship will find at paragraph Roman 6. Claimant had undertaken to set up the project and ensure that the commercial production of the end products is commenced in the shortest possible time. Claimant represented to the respondent that BuildMate was qualified and experienced in erection and commissioning of a unit of such magnitude. Then, my lord, BuildMate's, my lord, role is recounted for, my lord, a few lines. Then, my lord, paragraph Roman 7 says that, my lord, there were, my lord, avoidable delays. Well, I am instructed that BuildMate was, my lord, a contractor chosen by the respondent, but that really ceases to be of any relevance now. They talk about, my lord, certain delays, etc. Now, my lord, there are allegations made, my lord, with regard to, my lord, delay in completion of, my lord, the plant. But, my lord, please now see the principal allegation, Roman 10. Apart from the issues relating to different outsourcing and delay in setting up of the project, there were several technical issues with the plant and machinery, and the project could not produce competitive end products. The respondent entered into the agreement based on claimant's commitment of providing the following minimum assured production quantity as specified in clause 107 of the preamble to the agreement. That is, my lord, 600 metric tons, then 500 cubic meters and 400 cubic meters. Claimant had expressly represented its ability to manufacture the minimum assured production of the end products and had thus undertaken to do so under the agreement. Project was of a fairly large scale, and since the market was saturated with products of other companies, the respondent's profitability in the entire project was based on economies of scale and was thus dependent on the claimant's ability to manufacture the minimum assured production. The maximum output generated by the project against the minimum assured production was as follows. So, my lord, basically what they are saying is you could not achieve the minimum assured production. Now, well, so far as this is concerned, one very interesting feature is that there is no complaint that you are not being able to deliver goods to us. Now, my lord, this, my lord, becomes very important because ultimately, although the, my lord, designs and specifications are chosen by the respondent, although, my lord, the plant and machinery is chosen by the respondent, although the entire supervision of, my lord, the erection commissioning is done by the respondent, ultimately today they say that you are not being able to achieve the minimum guaranteed production. Now, my lord, so far as that is concerned, the first, my lord, thing that would then come to mind is that, my lord, there are repeated complaints. They are not being able to deliver, my lord, end product to me. And, my lord, lordship will kindly see, my lord, what is very important is here there is a representation that the market is saturated with these products. Well, that is, my lord, what I have just read out to your lordship. My lord, please have a look at this again. My lord, 1766. Third line at page 1766. The project was a fairly large scale, and since the market was saturated with products of other companies, respondents' profitability in the entire project was based on economies of scale.
This product is the end product of this project or the respondent company's product?
No, my lord, these are, my lord, products that I...
Saturation of what?
My lord, saturation of, my lord, the product.
Final cement product or the input product?
The input products, because, my lord, they say the market is saturated, so your profitability depends on, my lord, the economies of scale, which is, my lord, of course, the scale at which you manufacture these products and supply these products. At least that is, my lord, my understanding of what I've been able to glean from this paragraph. Because they have not said that because you have failed to supply, we have not been able to supply to our counterparts in the market.
They are saying that their profitability suffered because
The
of
claimant
your
was expressed repeated. The project was fairly and market was the respondents' profitability in the entire project.
respondents' profitability, their profitability.
On the entire project, my lord, profitability from this project. I don't really understand what they mean by this because, my lord, this is not really spelt out and, my lord, remains as vague as, my lord, they intended to keep it.
Before you proceed further, my brother has something to say.
Yes, yes.
Shaha, I just noticed this name, Ultratech Cement Limited. I had an occasion to appear for this. I mean, I had appeared for Ultratech, not in this matter, but in an unconnected matter, I have represented Ultratech.
We, my lord, have absolutely no objection to your lordship's, my lord.
No, no, my lord, we have no objection. In fact, the cause title should be corrected also in the cause list. My lord, we moved here, my lord, your lordship's, my lord, substituted Ultratech, but it's entirely.
You cannot have objection. He appeared for your client.
No, no, it's not that.
So we will record that. We will record that while we record an order today.
Not just that, my lord, if my learned
No,
judge feels uncomfortable, that's a different issue. My lord, that's the primary, my lord, issue. My lord, what we say should not matter. But my lord, we have, my lord, full faith. My lord, there is.
That your lordships can take it from both of us, my lord. My lord, no hesitation on our parts. But, my lord, if your lordship is, my lord, uncomfortable, then it's a different matter.
My lord, we had some hope. My lord, that will end here. Kindly.
No, his lordship is not comfortable. Hey. We are not inclined to take up this matter on the personal ground of one of us. Ebenam, bracketed. Paragraph, let this matter stand released from our list and be placed before the Honorable the Chief Justice for appropriate direction.
Hope your lordship didn't hear that.
No.
My lord, now that the lordships have released the matter, senior Mr. Nariman, my lord, was in court. I was his junior in a matter, and the Reliance matter was being taken up by a bench presided over by Justice Kapadia, yet to become the Chief Justice. And Mr. Salve was appearing for one of the parties. So when the matter was taken up, and a judge pointed, I have a few shares in Reliance, it would be proper for me to take it up. All the senior counsel there said, we have absolute faith in your lordships, kindly take it up. And the judge said, very well, then I just record that and proceed. Mr. Nariman, who was not briefed in the matter, got up and said, I record it that everybody have consented, that only gives you a certificate, but don't take up the matter. And then I asked him later, and he didn't take up the matter. I asked him later, says, whenever you are in doubt, whenever there's a conflict, irrespective of what anybody says,
Correct.
Which is why I tried to put in mildly.
Yes.
Say, lordship's uncomfortable. I am not one to press.
Yes, another thing, Mr. Mukherjee, today you are appearing, Mr. Shah is appearing. Tomorrow you may not be.
My lord, that is one thing what can happen later. But my lord, when your lordships, my lord, have this, my lord, responsibility, it's always, my lord.
Yes, yes. Somebody passed away, you said? No. There's a resolution or something?
No, no, to me, power. I'm sorry. I said some instruction. Political leadership at the bar, my lord. No. We were, my lord, we were all ready, my lord. We were hoping, my lord,
Sorry.
the pleasure, my lord, of doing this matter before election. But, my lord, that this is for Justice Rai, my lord. Friday, my lord, we are continuing. My lord,
Yes.
that matter, there's no problem.
No, that is an understanding that, my lord, that's a commitment to the court.
There was some urgency and Justice Rai's, my lord, agreed, my lord, to sit beyond court hours to conclude.
I don't think, my lord, your lordship will be required to sit beyond court hours. The matter is, at the end of the day, quite a simple matter.
250 crores.
No.
No, this one wasn't much.
No, not this.
Yes, my lord, that is 250 crores and above.
Very well.
Tender.
Exactly half, I think.
120.
Mr. Bose was appearing in this matter.
In person.
Oh, main person. And Mr. Ghosh was sitting there also.
Main person. My lord. I was, my lord, I came in much later, but what I argued, my lord, which found favor, my lord, with the learned judge was a point, my lord, which was given to me by Mr. Bose. All the points that I thought I had independently found to challenge the award were noticed, but were not the grounds, my lord, for, my lord, setting aside that 127 crore. Only Mr. Bose's point, my lord.
Now, Mr. Mukherjee came in at the 34th stage. I have come in at the 37th stage. That is the difference.
After this 136 stage. Narrator, we should follow.
Item number 7.
Your Lordship, I appear on behalf of the appellants, Your Lordship. I'm being led by Mr. Pratik Ghosh due to some health issues. He has not come to court today, Your Lordship. I'm humbly seeking for an adjournment, Your Lordship.
Adjournment for how many days?
Your Lordship, he was requesting if the matter can be made written on 18th of August, Your Lordship.
He then come on the 27th of August.
27th. Accommodation is prayed for on behalf of the appellant. কত নম্বর? Paragraph. Mr. Chaudhary, learned senior counsel representing the respondents, suggests that this matter may be listed again on August 27. Oh, only respondent number 1, respondents. Suggests that this matter may be listed again on August 27, 2025. Let that be done. Let that be so. Let that be so.
Oblige, Your Lordships.
For hearing, item number 12.
My lord, as usual, I am for the respondent number 2, my lord.
As usual, you are for the respondent number?
Time I also appeared, only I appeared.
Lordship, I am appearing on behalf of the respondent number 1. I have been laid by Mr. Dhruv Surane. My lord, I am praying for not today. Sir is engaged in court number 26.
The second call, Koro.
My lord.
Second call. For hearing, item number 12.
Oh.
My lord, one request I may make, because I had a talk with the other side counsel, my lord, in the morning. I was suggesting him that if I can pray before you to fix it on the next Monday.
Next Monday.
Next.
That is why probably they are not here. Very well. Next Monday.
I'll convey it to them.
Grateful, my lord.
Highly obliged.
On commercial bench, re-application, item number 1.
No, it's time for the respondent.
Pasu.
Not 3.
My lord, I'm appearing, I'm the appellant in person, my lord. On the last occasion, the respondent prayed for the adjournment. So my matter is a bit urgent matter because
Pass over. First call, pass over.
Second call, re-application.
না না পুরো লিস্টে রাখো।
Item number 1, item number 4.
Your Lordship, I am for the appellant. My senior is on our legs. He's coming.
5.
My lord, I am for the respondent.
Item number 6. 7. Item number 8. 9. 10. 11. 12. 15. 16. 16. 17. Item number 18 and 19. Item number 20. 1. Item number order, better. 24. 5. 26. 7. 58. 9.
Then Lordship after the respondent.
30. 51. 32. 33. 4. 5. 36 and 37. 38. 39 and 40. 51. 60. 5. 46. 47. 48. 5. 6.
I appear for the respondent.
7.
56 I am for the petition.
8. 9. 3. One. Second call. Clarification item number 1.
Restoration.
My lord, I am there. I'm not opposing, my lord, the restoration. I'm not opposing the restoration. Only thing, my lord, there was an interim order which both parties really were enjoying in a sense, my lord. Let that be, my lord, reinstalled or reimposed, my lord.
Yes.
I have not made that specific prayer, but Lordship will revive whatever interim orders was present. Page 9 is the order.
Lekho. What is that? Not necessary. This is an application for restoration of APO 97 of 2024, which was dismissed for default on July 17, 2025, along with GA2 of 2024. The paragraph, having heard learned counsel for the parties, we are satisfied with the explanation furnished for absence of learned advocate for the appellants on the day the appeal was dismissed for default. Paragraph accordingly, the order dated July 17, 2025, is recalled, stop. APO 97 of 2024 is restored to its original file and number along with the connected application, stop. The interim order that was in operation in the appeal stands reinstated, stop. Paragraph GA such and such is disposed of. Paragraph lists the appeal and the connected application on Friday date the other.
But instead of Friday, make
Monday,
it Tuesday.
next,
Very good.
next Monday.
So detailed. So detailed.
Monday.
Second call item number 2.
May it please your lordship, my lord, I am appearing on behalf of the appellant in this matter. The moot question which has fallen for consideration before your lordship, my lord, is whether the time to file the affidavit in support of caveat, as my lord permitted by the original side rules, is a mandatory time limit or not. Now, my lord, I am being led by Ms. Manju Agarwal, learned senior advocate. So, my lord, I don't think so she is here, but it would be fittest if she argues because she is, my lord, who had argued this matter before the learned single judge, my lord.
You have argued several matters before us.
Well, this has been argued by her, my lord. Although the research was to some extent done by me, we couldn't succeed before the learned single judge, my lord.
So what are you suggesting?
My lord, can it be taken up tomorrow in this instance, my lord?
Not today, Mr. Dutt. There are provisions both in the rules and the CPC for enlargement of time to do a particular
There
thing.
is, my lord, a specific provision in the original side rules for enlargement of such time limit. But we had relied on, my lord, a division bench of the Honorable Madras High Court. We would like to, my lord, persuade your lordship on those views.
Very well.
I'm not saying anything.
Item number 3.
My lord, I'm the applicant in person, my lord.
But before my
In brief, my lord.
Yes. My lord, the sum and substance of the order, my lord, there were two directions passed. One was the direction which, my lord, the learned judge clarified that the order of the learned judge staying the hands of the executor not to do any further to deal with the assets will not stand in the way of the executors complying with the previous order, which were there in another proceedings. Pursuant to that clarification, my lord, we had asked for certain medical documents from Apollo Gleneagles Hospital in respect of the deceased. That has been complied with.
You are the executor.
I am the executor.
You are Shugoto.
Yes. No. I am a Namtaki.
My lord,
You are Kaushik. You are Sugata.
I am Sugata Shankar. Please allow me to first present my case.
I'll not take much time. I'll not go on merits. I'll not go on merits. And the second
You're going
thing
on
is,
merits. Please allow me to
there
speak
was a
first.
direction upon the bank to file an affidavit disclosing who has operated the locker. Your Lordship will find in that order itself that I was passed by consent of the parties. These are the two directions. One has been complied, one was no appeal lies from that in my.
No, let us see what the impugned
Yes.
order is.
Yes, Your Lordship. Yes.
Yes.
My lord, in brief, the respondent had filed an application to obtain probate with respect to a photocopy of the alleged will dated 5th February 2020.
Mr. Roy, rightly, wrongly, probate has been granted.
Yes, my lord.
It has not yet been revoked.
Yes, my lord.
We have our doubts whether this order is an appealable order at all.
Okay.
We have a great doubts. What has been done? Nothing.
Yes.
Writ petition, 7th April order, upon submission of probate within 3 weeks, Glenicals to make available the medical records. Second, the locker operating register. Still, he is the executor. Probate in his favor still stands. So we see nothing wrong with this order. Now make your submission. The more you make, we'll see.
Yes, my lord. Please allow me.
Please go back and file your opposition, fight out your revocation application.
Yes, my lord. My lord, just 2 minutes I will take.
Yes.
My lord, please allow me. My lord, the application has been done rightly or wrongly. They have obtained the probate. Now, when we wanted to file an application for probate on the basis of a registered will, my lord, I have come to know on that point of time that the probate has already been obtained. So the first step which I took is obtaining the certified copy of the application for probate, the affidavit of assets, the consent given, the witnesses deposition, all orders. After reading those documents,
how are you related to Borsha Ganguly?
Borsha Ganguly is Srimati Borsha Ganguly treated me like a son, and I took her care for the last 1 decade or more, all throughout, for her admission. Everything I used to take care of her. She made me her constituted power of attorney registered. She has allowed me to take all decisions. She made me her joint account holders. She has everything. She treated me like my son. And finally, she wanted that with her wealth, a temple has to be constructed where her Gopal Thakur will be installed. She wanted that to get it done by me, for which she had made a deed of trust, registered deed of trust, where I am the trustee, and she wanted that I take care about the entire work because she loved me like a son and she trusted me more than that.
She did not have a family.
She did not have any issues. Her husband was also an eminent lawyer of Alipur Court. He also passed away. Her class 1, she had no issues. There were no class 1 legal heirs. She specifically in her will has specifically mentioned that her sister's daughter will be deprived from her assets because of certain reasons. She has specifically mentioned that her husband's sister, they will be deprived from her assets. So she made a will, and it is a registered will. It has been witnessed by 2 persons. The doctor, medical practitioner, has given a certificate in that will. And after doing everything, she made a video recording of all the documentations she has done, because she was not a simple lady. She was a wife of a very eminent lawyer. So she had some legal senses. So she, before passing away, she on her own did so much that I am really astonished that she has done this, thinking that today these things will happen. So, my lord, her last wishes should be respected by everyone concerned. And it is the duty of this honorable court to ensure that what registered will she has done and what she wanted to do. She has specifically stated that these persons for whom they are acting, they must be deprived from her assets.
This is your argument for the learned single judge.
Yes, my lord. Now, my point is, my lord, when I have filed an application for revocation and the assent
for the other learned advocate. Sorry, 1 minute. We will have to rise at 3:30 today. So this is the last matter we are taking up. This is entirely for my personal reason. Yes.
My lord, when we have filed our application for revocation, we have taken all the points and we have given the grounds why the entire unregistered will of which the probate has been obtained is suspicious. So that is under trial before the learned honorable single judge below. And at the time of hearing, the stay has been granted for the assent, and specific direction has been given to the propounder of the will as well as to the applicant not to make any transfer, any sale, and there should not be any encumbrance. There should not be any change in the nature and character of the properties mentioned in the will.
Mr. Roy, you have not challenged the 7th April order. passed in the writ petition.
My lord, I was not a party in the 7th April order, and everything has been happened behind my back, my lord.
Whatever it is, so long as that order stands, the learned judge has correctly recorded in the order, his lordship was not sitting in appeal.
Very correct, my lord.
Order.
But my humble submission is the learned read court has said, you submit the probate and then only we'll get the documents. And that probate, before handing over, has been stayed by the testamentary jurisdiction.
Has
Prior
been
to
stayed.
the read court has passed an order that they did this, in the read petition, they have suppressed the existence of the probate. And my lord, they have specifically said that you submit the probate and thereafter the hospital will hand over the documents. At this stage we have come and the stay has been granted before handing over the documents. Of the medical documents.
Stay of medical documents.
Stay of handing, stay of the grant which has been allowed.
Stay of the grant.
Stay of the assent which has been allowed.
Stay of assent.
Yes, my lord.
Assent should not be given for the time being.
Now the
probate still stands, sir.
But since the alleged executor is a person whose authority is under challenge, under the revocation application is decided, unless it is decided, he cannot claim any privilege access because medical documents are very confidential documents, and in terms of the judgment given by the Honorable Supreme Court in case Puttaswamy versus Union of India, medical documents are confidential documents, and the principles has been laid down because it is covered under Article 21 of the Constitution of India. It cannot be handed over to the person.
Yes.
My lord, it cannot be handed over to the person whom the testatrix never wanted to deal with. And so far the banking records are concerned, my lord, I have filed my affidavit in opposition on the very next working day. I have affirmed it. And after preparing, I have understood that whatever affidavit has been sought from the bank is basically a blessing for me because nowhere I'm involved in that. So if the bank gives an affidavit, whether anyone has any access to the locker from 1st January 2020 till the date of breaking the locker, which happened without my presence, without my knowledge. So it is a blessing for me because sometimes an application made by the other party becomes a blessing for the other party. So, but my issue is regarding the principle of law, whether a confidential document of the testatrix, which she never wanted to get it handed over to such persons, can be given to such person until the application for revocation is decided. And number two, at the time of hearing, it was my humble submission before the Honorable Judge below that I will file my affidavit in opposition. After seeing my affidavit in opposition, you please pass an order. The judge below, Honorable Judge below, has accepted that, has given me the opportunity to file an affidavit in opposition and asked them to file reply. I have already filed it. I have filed but before filing my affidavit in opposition to my reply to my revocation application, this order has been passed, making my affidavit in opposition absolutely infructuous. My humble submission is, please hear me. Then you pass an order. The heaven will not fall down within 10 days. So I just wanted to file an affidavit in opposition, which has been allowed. But at the same time, the interim order has been passed that you hand over these documents. Then my affidavit in opposition becomes totally infructuous. And that too, since my application for revocation is pending, the matter is now sub judice. So it cannot be said that the probate has been granted and the executor enjoys everything until it is revoked because it is sub judice now. This is my humble submission before you, my lord. Let the application for revocation be heard, let an order be passed, and thereafter whatever can be done. That though it's not within my hand. I have followed the procedure of law. I have filed an application and now I will file an application for probate. Today I have received that, I have made certain amendments that has been allowed. I have received the amended copy today. I will serve them as per the direction. And my humble submission is let the application for revocation be heard and settled, and thereafter whatever documents they want, they take it.
That is all?
Yes, my lord.
Tomorrow for orders.
Much obliged.
Hey. Okay. We have heard the appellant, Mr. Roy, who appears in person. Stop. He concludes his submission. Paragraph. We have not called upon the respondent to argue. Paragraph lists the matter under the heading for order to within inverted comma. Calculated the on such and such before appellate side matters. Key. Tomorrow we'll pass the order.